Hello, hello, hello again, and welcome back to Freedom Ain't Free. Today's video, we're going to be talking about how to leave an inheritance to your children's children. Estate planning 101, wills and trust. I want to take an opportunity to focus our attention on these individual pieces of the puzzle to point you into these individual directions. Here at the Freedom Ain't Free channel, we want to make sure that we share with you and that you have all the wisdom, knowledge, and understanding that you need of all of the financial products that are available to be used in our country on today, right? And give you the ability to know about them and understand them and be able to put them to use. My name is Joel Huey. I'm the principal at ARC Financial Strategies, where predicting the rain doesn't count, building the ARC does. Our objective are to work with our clients who we consider Henrys, high earners, not rich yet, have figured out how to produce some income, but need some help in getting themselves financially free. Here at ARC, we help our clients to develop a portfolio of $2 million so that they can have the income necessary coming from those assets so they can be financially free, pursuing the things that they want to pursue in life. If you had $120,000 to $160,000 a year coming in from your asset to put you in a position to be able to accomplish all that you want to accomplish with your free time, get out of the rat race. There's a link in the description of the video. You can book a session, and we're going to provide you with what we like to call your freedom number. How much money you need to save on a monthly basis in order for you to develop that $2 million portfolio and live financially free. In today's video, we're going to jump into estate planning 101. I am not an estate attorney, but we do have estate attorneys on the team, and we do have a will and trust processing service that we'll talk about later. There's also a book that I want to recommend that you can utilize in putting all these pieces of the puzzle together for yourself, so make sure you stay to the end of the video to get that link. So when we're talking about estate planning, we're talking about helping you to create this piece of your puzzle. I want you to understand that there's 7 steps to your financial success, and this is just one piece of the puzzle, but it's important for 5 very specific reasons. Number one, you want to be specific in how you distribute the assets and the arc that you built through your lifetime. Secondly, you want to make sure you name guardians for your minor children. Thirdly, you want to make sure that you have designated somebody to manage your personal finances in case you become incapacitated and can't do that for yourself. You also want to be able to specify your medical treatments, right? Which procedures do you want and which ones do you not want? And then, of course, we always want to minimize potential estate taxes and avoid probate at all costs. So I live in the state of Virginia, and in the state of Virginia, everybody is going to have an estate. Unless you have a trust and you're able to skip that process. But generally speaking, when we're talking about estate planning, you want to understand that your estate's basically going to be distributed in 3 different ways, right? So first is by law, right? So if by the law of the state, something transfers from one person to another, that skips the probate process because another law comes into play. What are you talking about, Joel? So as an example, my wife and I are married, so our marital home is owned by us both, right? And it transfers through Commonwealth law of survivorship. So if my wife precedes me in death, the house automatically belongs to me. If I precede her in death, automatically belongs to her. The second type of estate planning transfer is by contract, right? So by contract. So I have a life insurance policy. My wife is the beneficiary of my life insurance policy. I die. The life insurance company will write a check to my wife. That process skips the probate process. And then the third is by probate, right? So there you would go, the state would go and sit in front of the judge, and the judge would distribute any remaining assets, subtracting off any liabilities, and then distribute that to the heirs of the estate. So when you get there, this is where your will comes into play. Your will gives instructions on how you would like for your estate to be distributed. So there's a will and there's a trust. So we're going to talk briefly about the differences between the two. A will, also known as a last will and testament, is a legal document that communicates your desires regarding the distribution of your property and the care of any minor children after your death. The person who carries out the instructions in your will is called the executor. You can also have a trust. A trust is a legal arrangement where you give control of your assets to a trustee for them to manage and to distribute for your beneficiaries. Trust can be set up to operate during your lifetime, which is a living trust, or after your lifetime, after your death, which is a testamentary trust. Those are basically the differences between the two. When should you when should you do a will? When should you do a trust? We're going to encourage you to reach out to a state attorney or work through our processing process to help you make that determining factor. We will send you a guide to help you look through. But in general, there's four things to take into consideration when you're thinking about the trust. So first of all, the size of your estate, right? In other words, right? How much money do you have, right? So if you have less than $1 million is my recommendation, that a will suffice. If most of your assets are tied up in either a family home or investment accounts where you can leave a beneficiary listed. Once you get past that point, we're going to really want to start looking at the trust. Secondarily, to think about are your privacy concerns. So if you have particular things that you don't want discussed in the general public, you're going to want to trust. Everything that's in your will become public information that anybody can look up any day of the week. If you don't want that, then you want to set up the trust. And then, of course, cost and complexity. There's a difference in the price between setting up the will and setting up a trust. You can go into the description of this video. We provide a processing service that will help you put together the will and or the trust together with you, and the fees are explained there. The next thing you want to think about, whether you did the will or the trust, is choosing your beneficiaries. And when you're choosing the beneficiaries, there's a couple of things I want to bring to your attention, or things for you to think about. Number one, family members and loved ones, right? Spouses and children, other family members make great beneficiaries, somebody to leave your assets to, but you want to think through who is getting which piece of the puzzle. Also, friends and non-relatives, right? So somebody who's been a part of your life that's not necessarily flesh and blood, but was very important to you in your life, you may want to consider them as a beneficiary. You also have charities and organizations, right? If you want to leave something to your church, if you want to leave something to another civic organization. And then, of course, you can name your trust as the beneficiary of all of your assets. That would move everything from your estate to the trust, and then, of course, the trustee of the trust would manage the trust for you. Now, next piece of the puzzle to think about is leaving gifts and heirlooms, right? So I always tell my clients, don't make your kids fight over the salt and pepper shakers, right? Those little things that you think don't matter, right? So in our family, we have a little funny joke, right? That I use the same spatula all the time when I cook, right? I use the same knife set all the time when I cook, right? And so I know my children are going to want that tool and those tools, right? So you want to make sure that we avoid the arguments, right, by making sure that we leave those to the people that we've decided that we want to leave them to. So when you're thinking about that or you're considering your gifts and your heirlooms, a couple things we want you to think about. Number one is the value of the gift, right? So you want to try to distribute things as evenly as you possibly can. You also want to think about your personal ties, right? Who has more connection to the item, right? You want to think about equity, right? What's fair amongst the family or within the family, or how you all have set up, your family overall. You want to have open communication. Hey, let's not wait until the end of the process to have this conversation. Let's talk about this stuff now so we can clear the air so you guys know exactly how I feel on the front end. And then you might want to consider a no contest clause in your will, which says if you contest this will, you get nothing. That way we avoid them saying, okay, well, I'll just wait till you die and we'll argue about it in court, right? So you can put in that clause that says if you contest the will, you get nothing. Let's talk about the differences between executors and trustees, right? So it basically boils down to whether you set up the will or whether you set up the trust. So an executor is somebody that if you have a will, you choose to be responsible for carrying out the instructions after your death. This includes paying off your debts, filing your tax returns, distributing your assets to your beneficiaries, right? That's the job of the executor, to carry out your wishes or your instructions. Versus a trustee. A trustee manages the assets of the trust. So first and foremost, we have to leave assets in the trust for the trustee to be able to manage. You can act as a trustee while you're living, and then you can appoint a successor trustee to take over at your death. But if you're choosing an executive or a trustee, a couple of things that you should think about. So first and foremost, the trustworthiness of the person, because you're going to be giving them authority and access to your $2 million portfolio. We want to make sure that we are picking the right person. Secondly is their organizational skills, right? How are they doing in handling their own personal affairs? If they're unorganized with their own personal affairs, you might want to choose somebody different to carry out yours. The next is financial knowledge. And they don't have to be an expert. They don't have to be an investment advisor or a financial services professional. But, do they have some basic knowledge or basic understanding of how financial tools work? Next is the availability and the willingness to serve, right? Do they want the job, right? In other words, so, make sure you have a conversation about them, explain to them what you like for them to do, and then get their agreement to fulfill it. And then, of course, age and health, right? You want to try to avoid executors or trustees that are older than you or that are right around the same age as you, because more than likely, whatever is going on in your life during that time frame is going to be going on in their life. Next piece of the puzzle we're going to talk about in your estate planning is your young children. And what is your backup guardianship plan? Right? If you die before your children become adults, who's going to be responsible for carrying out your wishes in regards to your children, right? So if you're married, of course, your children would be cared for by your spouse. But if there are specific things that you wanted to be done for your children or to your children or with your children, you might, create a guardianship arrangement in that space. If you're not married, you definitely want a guardianship arrangement so that your wishes can continue to be, poured into your children's life. But a couple things you want to consider when choosing a guardian. Number one is their willingness to serve, right? Make sure that they are on board with stepping into that role. Secondly is age and health, right? You want to make sure that they are old enough for the responsibility as well as healthy enough to carry it out. Location, right? Are they hundreds or thousands of miles away from your children, or are they nearby, right, where they can fulfill the requirements that you have set in place? Nextly, their parenting styles and values, right? Are they aligned with yours, right? Do they do the same things you do? Do they believe the same things you believe? Do they build their family? Are they building their family on ways that you believe, or even sometimes they maybe have higher requirements than you do, right? Secondly is their relationship with your children, right? Do they know your children? Do your children know them? Have they already met? Do they spend time, at their home? Those pieces of the puzzle. And then, of course, lastly is the financial stability of that person or that family that you're going to take this burden of your child and lay on top of them, right? If they're not in a position to be able to handle their current situation, unless you're planning on leaving resources to take care of your child, right? We want to make sure that the guardian is going to be in the right financial position to be able to handle the additional burden of your child. Okay, a couple more points and we're going to wrap up on today. So I want to talk a little bit about your financial power of attorney. So if you're incapacitated, right, what is a power of attorney? It's a legal document that grants a person referred to as an agent or an attorney, in fact, the power to manage your financial affairs. That's what a power of attorney is, specifically a financial power of attorney. It can give them permission to pay bills, manage your investments, sell or buy property, make other financial decisions. So when you're choosing somebody to have financial power of attorney in your life, a couple things you want to think about. Number one, are their trustworthiness. Number two is their, financial savviness, right? How many things, right, have they been exposed to? If you're giving them a portfolio that they haven't built themselves or have one similar, that could create challenges. Their organization and diligence, right, to detail, right? You want to focus in on that. And then, of course, their willingness to serve, right? You always want to have conversations with people before that you give them burdens. The thing to understand about financial powers of our attorneys, if it gives that person the right, to make changes and adjustments in your personal finances, right? So if you're incapacitated and you can't pay your bills and manage your investments, somebody's going to need to be making those decisions. So you want to make sure that you have picked the person that you want to make those decisions and not just dump that responsibility into your children's lap or your spouse's lap, who may not be in the have the financial savviness in order to manage a $2 million portfolio, right? So you want to make sure that you're thinking that all the way through when you're choosing that person. The next is the medical power of attorney, right? So a medical power of attorney, also known as a healthcare proxy or a healthcare power of attorney, is a crucial document that ensures your healthcare decisions will be respected even when you can't make them for yourself, right? So you want to make sure that you have a document and a person who's going to speak to your health the way you want your health spoken to, right? They're going to make those challenging decisions that you're not in a position to make. Maybe you can't speak. Maybe you're unconscious. Whatever is going on, you're in a coma. And somebody's got to speak on your behalf and make those medical decisions. You don't want to leave that to just, the hospital thinking it through and doing what's may be in the hospital's best interest, not necessarily in your best interest. So you want to make sure somebody's got the ability to make those decisions and speak during that crucial time in your life. A couple of things to consider. First and foremost, trustworthiness. Secondly, their ability to handle stressful situations, right? So they're going to not only have to navigate through the nurses and the doctors, but they're going to have to also navigate through the rest of your family. Their availability, right? Are they near you, right? Are they going to have to uproot their lives and come and move to a place where you live in order to be able to enact in that way? And then, of course, their willingness to serve. So that's the thoughts about a medical power of attorney. Lastly, is some of your end-of-life considerations, right? So there's some things to think about, some things to put in place as you're thinking about how you want to make your transition on into the next phase of life. So a couple of things to want to think about. First and foremost, we've already talked about the will and the trust. The second thing you want to think about is your final resting place, right? Do you want to have your remains cremated? Do you want to have them scattered? Do you want to have placed in a grave? Do you want to have them potted in a tree? Planning your final arrangements. What do you want the service to look like? Those pieces of the puzzle. Who do you want to speak? All of those things you want to put into the plan. And then finally, are you going to have a full-fledged funeral, or are you going to have a memorial service, right? So when you pull all of those pieces of the puzzle together for your end-of-life considerations, you want to make sure you have all of those documents in your will and or in your trust, or you want to give discretion in that area to somebody, and they can make all of those decisions. And so we kicked off this video by talking about, how to leave an inheritance for your children's children. So a couple of different things I want to share with you there. First and foremost, of course, here at ARC Financial Strategies, our goal is to help you to create a $2 million portfolio that's going to spit out $120,000 to $160,000 a year for you during retirement and creating financial freedom for you. And so within that portfolio is going to be a couple of different tools that we talked about in some previous videos. You could go back and look at those and get each and every tool that goes into that place. But what's most important is the tool that's going to transfer the assets to the next generation and the generation after that. So whether we're using life insurance tools, whether we're using inherited IRA tools, or whether we're using QUILAC tools, right? There's several different tools that we can utilize in place to take your assets, transfer them over to the next generation, and subsequently create another portfolio that will go to the following generation. That $2 million portfolio we designed, we will put together in a way that will keep spitting off that income generation after generation. All we have to do is make sure that the next generation gets the education that goes along with what I like to refer to as don't kill the tree, live off the fruit. Also, we'll promise you guys at the end of the video that I was going to give you a book to read. So here's a book for you. It's called Nolo's Guide to Estate Planning. The link is going to be in the description. You can grab the link, get the book. It'll walk you through step by step on how to put your estate plan together all by yourself. If you want to have some help, we do have a preparation service where we will work with you to put together your will and or your trust, or we also have attorneys, estate attorneys on staff that can do the whole package for you all together. In the link is a link to the preparation service that we provide, and all of the pricing and all the information. You click on the link and get that account set up. We'll reach out to you and help you put your will and your trust together. Once again, I, Joel Huey, am not an attorney. I'm not providing you with any legal advice. I'm simply giving you access to a service that will allow you to do that for yourself. If you want to reach out to us and speak with one of our attorneys, we can set that up for you to work with one of our estate attorneys that we have on the team. Thank you so much for joining us today. We appreciate you carving out some time. We want you to remember that freedom ain't free. See you guys next time on our next episode.